as a country, there was a lady called Wangua Wamakeri. Wangua Wamakeri was a very courageous woman. She rose to a position, or a political position, within the Kikuyu community. And the men feared that she treated them very badly. To such an extent that the men took an oath and said to themselves that never again shall they be ruled by a woman. My Lady Chief Justice, we still have some people within our own society, particularly men chauvinists, who seem to think that you may turn out to be like a Wangua or Makeri. They fear that you may probably not be someone who will listen to them. But we who have known you for a long time, we know that there's no way you can become Wangua or Makeri. You will treat men and women gradually. The Honorable Lady Chief Justice, yourself and your deputy, you join Club of Great Women of Kenya. You join women like Mora of Kisii, who fought the colonialists very energetically. Lately, the two of you join great women like Professor Wangari Maathai, whom I had the privilege to appear for in court, to represent her in many cases, a very bold woman who was tortured, but she stood firm, and she deserved to get the rank of, to get the prize of a Nobel Prize as the first African woman in this country. My Lady Chief Justice, I would like to mention one or two people who have not been mentioned at all. I think that it's appropriate that we should mention our first Chief Attorney General, the Honorable Charles Njonjo. He had his own shortcomings, but it's not appropriate for us, according to the African custom, to emphasize the shortcomings that he had at all. But he was our first Attorney General, and he was Attorney General for about 21 years. But one thing that he stood for, and which we shall remain grateful to him as a community and as a country, in that he was able to preserve and stand for the sovereignty of our country. At that time, the country was going through a very difficult time. We had coups all over Africa. We had people who wanted to secede from the Republic of Kenya and go elsewhere. Some of our neighboring countries were making claims to our borders and so on. But he stood firm, and he was able to protect the executive, to advise the executive, and we were able to preserve the sovereignty of the country. We must remain grateful to him. I would also like to mention two other people. I mentioned Zamba Kitonga, who was one of the first chairmen of the Constitutional Review, a great Kenyan of impeccable character and integrity, but it's unfortunate that he is no longer with us at all. I would also like to mention Professor Yash Gai, a very great son of Kenya. He is the one who has developed constitutional and public jurisprudence in this country, perhaps more than anybody else. We stand grateful to him. He is still alive. I haven't been able to meet him for a long time, but I'm told that he's in Kenya. He is living in Nairobi with his lovely wife, Professor Cottrell. Now, if you may permit me to come to why we are here this morning. My lady, I will repeat what I said on my opening words before the Court of Appeal. I will repeat to you. As a country, we have been extremely unfortunate in that we have had a poor crop of politicians. The first crop of politicians that we had in the country measured very favorably with world leaders, with world politicians like Gandhi, like Kwame Nkrumah, like Nehru, and others. That was Mzee Jomo Kenyatta and his colleagues in the first government, people who fought for independence. They had grand ideals for this country. But then thereafter, after their demise, we have now current politicians, and there's very little really to admire them for. Recently I said in Court of Appeal that most of them you get the impression that they are job seekers, they are office seekers. And they come up with things like amendment of the Constitution because they want to continue to be in power. They don't seem to have really much that they can offer the country. Now, I would like to emphasize one thing, my Lady Chief Justice. To look after a country, you must have a creative mind. That is very important. You must have a creative mind where you are able to come up with ideas that can be able to rule the country. And whenever you have a poor politician who runs short of ideas, the immediate thing that he will tell you is that let us amend the Constitution. And that is what precisely happened with the first Constitution. It was amended many, many times, to such an extent that it ceased to be a Constitution. It was not better than toilet paper at all. We were not proud of it at all. And some of the problems we have at the moment is because of the frivolous amendments of that Constitution that was now overthrown by the 2010 Constitution. Now, there has been a lot of talk about basic structures. I do not wish to dwell very much to go into what has already been said by my very able learned friend. And at this stage, probably I should mention my able learned friend, Mr. Harvey. I thought he did a very good job. He opened the case very well, and he exhibited the impression that he is a person who is very well read and has read the brief very well. I do not wish then to go into a lot of details at all. And I may point out at this stage, my Lady Chief Justice, that should I try to repeat myself, I would have no objection if you tell me that kaminwa, we have already heard that, move on to something else. Now I will refer you to the Constitution of Kenya straight away. May I refer you to the preamble? The preamble of the Constitution of Kenya is very important when you are considering the question of basic structures. Acknowledging the supremacy of the Almighty God of all creations. My Lady, may I pause there? That first sentence, acknowledging the supremacy of the Almighty God of all creation. My Lady, it shows that there is something above the Constitution, written Constitution of Kenya. It brings in the concept of natural law. And if any amendment or any proposed amendment is against the supremacy of the Constitution, the supremacy of the Almighty God, that amendment must be struck out. It's a higher law more than the Constitution or the other written words that we find in the Constitution. Honoring those who heroically struggle to bring freedom and justice to our land. Again, that reminds us very emphatically that we should not forget the history that this country went through at all. Dirty and rotten history of assassinations, people having to fly from this country, of the Nyayo era, And at this stage, I may probably My Lady Chief Justice, I've got the book here, a sad book. We lived to tell the Nyayo story. I am almost crying. These were people who were tortured, who slept in cells with water. Some of them thereafter died immediately. They were not fortunate to live as long as kaminwa is living at all. They could probably have lived much longer. We have them here. It shows the history of Kenya. My lady, we should never forget the history of this country. And I'm afraid to say, my lady, we still have elements within our society, within the Kenyan society. If you do not stand firm and strong, they would like to take us back to those days of the Nyayo era. We had people leading the country, great minds. My contemporary at the Lions Day School, Nganga Tiongo, living in America. He cannot live in this country at all. Alamin Mazrui, living in America. He cannot live in this country at all. In brief, I'm making a point to you that the constitution that we have at the moment was deliberately made unamendable. Was deliberately made unamendable. And I refer you in this case to the book called Constitutional Amendments, Constitutional Amendment by Rosenai. I refer you to page 258 of that book. Page 258 of that book. It mentions Kenya, and it says Articles 255 to 257, different procedures for different provisions. The heading is that these are provisions that are, although they are provided for in the Constitution, but they do not have the force of law at all because they cannot be properly interpreted by the courts at all. So I'm taking the position, my Lady Chief Justice, that the Kenyan Constitution, if you read it very carefully, the entire Constitution, it seems to have been drafted in such a manner that, strictly speaking, this Constitution is not amendable at all. The idea being that if you allow people to amend it, we shall, within a short time, not have a constitution at all. Now, if I may now take the court to the preamble again. Proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. My Lady Chief Justice, that is where one of our problems we have. That is one of the problems we have as our country. And I refer you to a little book that I have. The book, the title of it is Making Constitutions in Deeply Divided Societies. Making Constitutions in Deeply Divided Societies, by a lady called Hannah Lana. Making Constitutions in Deeply Divided Societies, by a lady called Hannah. And I will read only, with your permission, I read only 2 words, or 3 sentences. Nearly 190 national constitutions are in force today. More than half of them have been written or rewritten in the past 3 decades. Many of these constitutions begin with some versions of the famous 4 words, "We the people." Now, my Lady Chief Justice, we the people, are we really a cohesive society? We are tribes. Our political parties are tribal political parties. They share jobs in advance. Jobs are given according to what tribe you are. Whether it should be that, it should be that, and so on. We are already tribes. So we have a problem. We cannot speak of a society or a community that is cohesive at all. We are very far from that. And we are only kept together as a nation by the 2010 Constitution, amended some sections, parts of that Constitution. The inevitable result will be chaos in the streets of Nairobi, chaos in the streets of Mombasa, chaos in our provinces. We need to nurse it. We need to nurse our Constitution so that we give it opportunity to be fully implemented and to grow. In other words, my lady, what you have to do when you are making any decision, you must exercise restraint. You cannot just go out and allow politicians to say they want to amend this Constitution at all. First, to make it was a big job, was a very difficult job. Now it's better that we keep it as it is. There are some individuals, for instance, who have come up with a bill. They suggest that we should have a president and deputy president, and then prime minister, and several other positions. These are intended to create jobs for people whom you can actually call tribal leaders in the country. And the small tribes will be discriminated against. The majority will discriminate small tribes of the country. Let us not buy the idea when they tell us that we shall have a more stable society, a more cohesive society, if we implement we implement the bill by giving jobs to certain individuals. We shall be entrenching tribalism, ethnicity in our society, where you have only certain communities that have been given certain jobs or certain positions in looking after the country. Permit me to go further. There is a respect for environment, which is a good idea, and there is a committed to nurturing and protecting the well-being of the individual, the family, communities, and the nation, which we stand for, recognizing the aspirations of Kenyans for a government based on the essential values of human dignity, equality, freedom, democracy, and so on, and then exercising our sovereign and inalienable right to determine the form of governance and so on. The point is that this preamble is actually like the ideology that the country stands for. In interpreting Kesavananda case in India, their lordships, the judges, relied on the preamble to the Indian Constitution. The preamble to our Constitution is very important. We cannot afford to ignore it. And in this regard, may I refer you to the authority that supports this submission that I'm making to you. find the book very quickly, but I have a book that has been written by one of the authors in which he is emphasizing that the preamble can be relied upon in interpreting the Constitution. I may yes, I found it, hidden itself. I'm referring to a book called Interpreting Constitution, a Comparative Study. Interpreting Constitution, a Comparative Study, edited by Jeffrey Goldsworth. Interpreting Constitutions, a Comparative Study, edited by Jeffrey Goldsworth. And it says this at page 247. The court, that is the Indian court, the court has used the preamble of the Constitution as a basis for articulating the basic structures of the Constitution. That is a preamble. The preamble, the court has used the preamble of the Constitution as a basis for articulating the basic structure of the Constitution. And may I refer to the same book before I lose it again at page 265. And with your permission, let me read it to the Honorable Court. Despite its shortcomings, that's the Indian Supreme Court, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities. May I pause there? There are some individuals in the streets of Nairobi who may say, why should the judges have such power? Why should the Supreme Court have such power? Why should the Court of Appeal have such power? Why should the High Court have such power? Because they are not elected members of society. But the learned author is telling us this, that the power to amend, the power to guard and look after the Constitution in India is no longer with the elected members. It is no longer with elected members. May I again read this provision very shortly. Despite its shortcomings, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities, such as President. President of India is not elected, the Honorable Chief Justice. The Election Commission, the National Human Rights Commission, and the judiciary. So the point I wish to emphasize to you is that you do not have to be shy to make decisions at all. The fact that you are not elected people is neither here nor there. You are a powerful institution that should protect our 2010 Constitution. It goes on, the Supreme Court, as the apex court with the power of judicial review over all other authorities, has shouldered the heaviest burden. Its assumption of power to review constitutional amendments, which our law also provides for. You can review the constitutional amendments, has made the most powerful court in the world. My Lady Chief Justice, we want this Supreme Court to be the most powerful court in the world, to be the most powerful court in East Africa, to be the most powerful court in Africa. May I again continue? Has shouldered the heaviest burden. Its assumption of power to review constitutional amendments has made it the most powerful court in the world. It has evolved from a timid positivist court into a very activist one. Its more prominent policy-making role has stemmed from its expansive interpretations of fundamental rights and directive principles, and its liberalization of procedural rules governing access to justice. Through its development of that role, the court has earned widespread legitimacy, which has helped to ensure that its decisions have been generally obeyed. My Lady Chief Justice, now that you are sitting on that chair of power, we are asking you respectfully that you give interpretations to the law, to give it interpretation to the Constitution, so that this case or this Constitution or this court becomes the most powerful court in this country and outside this country. My Lady, I've just been reminded by my junior, Valentine Kaminwa, that I've only 7 minutes to go. May I say with respect, I know that you have been giving people 15 minutes or 10 minutes or so on, but if I may say with tremendous respect, I usually think that I have a creative mind, and I can say quite a bit, not for selfish reasons, but I can say quite a bit that can help in shaping the jurisprudence of the country. I ask you very respectfully that you extend my time, that you do not give me only 15 minutes or 20 minutes to address you at all. You give me a little bit longer than that. I think that I can make a contribution to the jurisprudence of this country. My Lady, you remember I talked about the sad history of this country. May I make a reference to 2 books only? I would refer you to a book called Kenya, A History Since Independence by Charles Hornsby. Kenya, A History Since Independence by Charles Hornsby. Charles Hornsby, my lady, has got a Doctor of Philosophy in Kenyan politics. And in his book, he sets out the serious shortcomings that the society, the country has had. I will refer you also to another book, which is written by Daniel Branch, Kenya, Between Hope and Despair. The title tells you a lot. Between Hope and Despair, between 1963 and 2020. No wonder that our former President, Kibaki, a very learned president, when he was being sworn in, he said that he was inheriting a seed that had caused misrule for a number of years in the country. I will also refer you to Article 2 of the Constitution, supremacy of this Constitution. Supremacy of this Constitution. It's my humble submission that just from these 4 words, supremacy of this Constitution, one can state that the basic principle applies in Kenya. Supremacy of this Constitution. What that means that anything that is in conflict with the supremacy of the Constitution must be declared void.